everyone. Thank you so much for joining us for the most interesting topic that everybody loves, standard contractual clauses, especially after lunch. So we promise this will be exciting and intriguing, right? My name is Gabriela Zanfir-Fortuna. I'm Vice President for Global Privacy at the Future of Privacy Forum, a think tank and nonprofit organization lucky enough to be working in Brussels as well as in Singapore and having a global view from Washington, D.C. The reason why we are here today is to discuss, again, everybody's favorite topic, standard contractual clauses, because even if they sound as a very dry subject matter, they are in fact the instrument that moves personal data around the world, much more than perhaps any other transfer mechanism. Recent research from our colleagues from the International Association of Privacy Professionals showed that right now we have about 20 sets of model clauses, standard contractual clauses proposed or already adopted in jurisdictions around the world. Now, 2 of those sets are very, very relevant and impactful. One of those are the EU standard contractual clauses, which are one of the transfer mechanisms under Article 46 GDPR. And I would say the transfer mechanism of the day, referring some recent enforcement activity, right? But also, for those of you who are not aware, ASEAN has adopted about 2 years ago, more or less, a set of model contractual clauses meant to support data transfers across the countries that are members of ASEAN. Very recently, my colleagues at the Future of Privacy Forum have conducted research into how can we compare some of these sets of model contractual clauses. We focused on the ASEAN MCCs, the EU SCCs, and the Ibero-American Model Agreement, the Ibero-American Networks Model Agreement. And we were very pleased to discover that they had actually a lot in common. Following that research, we were even happier to discover that the European Commission and ASEAN have in fact been working for a while on bridging specific clauses and specific topics from these 2 sets of model clauses. And we will be finding out more today about that work. And I think an announcement is going to be made today. So I'm also very curious to hear about that. Please allow me to introduce our distinguished speakers. To my left, we have Ms. Denise Wong, who is the Deputy Commissioner Designate of the Personal Data Protection Commission in Singapore, and also the Assistant Chief Executive Designate of the Infocom Media Development Authority in Singapore. Welcome, Denise. Welcome to Brussels. To Denise's left, we have Alisa Vekeman, who works at the European Commission in, dare I say, one of the busiest units out there, the International Affairs and Data Flow team of the DG Just in the European Commission. She led the work on the modernization of the standard contractual clauses, and she led the work on the adequacy talks with South Korea, and is a member of the team that engaged with the US government on the new EU-US data privacy framework for transfers. Welcome, Alisa. And to my right, we have Philipp Raether. I'm pretty sure I mispronounced your last name, but I know you'll forgive me. Who is Group Chief Privacy Officer at Allianz. And for those of you not familiar with the company, Allianz is a global insurer and asset management company. Welcome, everyone. And Denise, I will first go to you, perhaps to tell us a bit about ASEAN and introduce also the announcement of the day.
Thank you so much, Gabriela, and thank you all for being here today. I'm very pleased to have this opportunity to share about ASEAN as a regional bloc and developments on data protection in this part of the world. I just first wanted to acknowledge our ambassador who is here, as well as our colleagues and friends from various ASEAN member states who have made the time to be here today. But I'm also very, very pleased to launch, together with the European Commission, a joint guide to ASEAN Model Contractual Clauses and EU Standard Contractual Clauses. This is an important piece of work that we've been working together on for almost 2 years now, and it's finally bearing fruit today. And we really want to mark this special occasion. But before that, maybe let me give a quick introduction to ASEAN. It was established in 1967 and is an association of 10 countries: Brunei, Cambodia, Indonesia, Laos, Malaysia, Myanmar, Philippines, Singapore, Thailand, and Vietnam, each with our own unique political, economic, social, and cultural backgrounds. We cover a geographical area of 4.5 million square kilometers, a population of over 650 million people with a GDP of 3.3 trillion. It's a very different animal from the European Union. The ASEAN member states are at various stages of development. Each country's laws and regulations are developing at different stages. Only a few member states have had general data protection laws in place for a long time, and data protection authorities have been established. Some member states have recently enacted data protection laws and are in the process of looking at how to set up data protection authorities, and another few member states do not yet have data protection laws. Having said that, the rapid digitalization and the rise of the digital economy, ASEAN recognizes the importance of data protection, building a trusted system where data can flow across borders safely and securely. And with no common data protection laws and regulations, ASEAN came together to adopt the ASEAN Framework on Personal Data Protection in 2016. And this was a set of baseline principles that were closely modeled after the OECD privacy guidelines and the APEC privacy framework. So having established and adopted these ASEAN principles, we then endorsed the ASEAN Framework for Digital Data Governance in 2018. And then that led on to the ASEAN Model Contractual Clauses, which is really a set of baseline contractual clauses for transferring data within ASEAN. Now, the ASEAN MCCs are quite unique. I'll just explain it a little bit. They are voluntary, and they provide a flexible template applicable to all companies within the ASEAN member states, despite varying levels of maturity in data protection across ASEAN. For countries such as Singapore and the Philippines, where data protection regulation is well established, we have issued regulatory guidance to provide greater certainty that the companies in our countries using the ASEAN MCCs will be considered to have met the transfer limitation requirements under our respective data protection laws domestically. That has been an effort within ASEAN to introduce regulatory convergence despite very different economic and legal contexts. Thank you.
If I can you also introduce a bit the guide that you have been working on together with the European Commission, just for an initial announcement?
Sure. So the guide is really a referential guide, maybe in a little bit similar to the work that FPF have done, but putting it together. But it was really in order to get a sense of where the convergence was. And it was very important, I think, for ASEAN and for European Commission to look at that comparatively and to understand where is that baseline of convergence. And the outcome and the importance of it was really as a signal to companies who are using, who want to use contract as a transfer mechanism and transferring data to Europe Europe, for example, or out of Europe to understand where those baseline convergence was. So this was a very important project for us in ASEAN, for sure, in order to get that baseline understanding. So I think Alisa can share more as well later. Yeah.
Thank you so much for that. And we will dig deeper in the second round of questions. But before we get there, Alisa, perhaps you want to share the work of the European Commission to modernize standard contractual clauses. It was kind of a lot of work, and I know they were launched some time ago. How has that been? Why did the Commission engage in that exercise, and how are you seeing it in practice?
Yes, sure. So I think most people here know that in the EU, model contractual clauses as a transfer instrument have been around for a while. I mean, the first ones were adopted, I think, around 20 years ago. So they are, in our system, they are a voluntary tool, so companies can decide on a voluntary basis to implement them in their commercial arrangements with their business partners, basically to transfer personal data outside of the EU, and in that way also comply with the requirements for international transfers in our data protection rules. And what we've seen, actually, especially in the past years, is that they are really by far the instrument that is most used. So there are some figures saying that about up to 80 or 90% of all data transfers outside of the EU take place on the basis of these standard contractual clauses, or SCCs, as we call them. And we see various reasons for that. We think that there are a number of benefits to using SECs. So one is that they are pre-approved. So as I said, they're a model instrument. To use them, companies do not need to obtain additional authorizations from, for example, a data protection authority. Their content is also fixed, and that makes it a lot easier to use them. So they're basically an off-the-shelf tool that companies can take and implement into their contracts. There's no need for lengthy and costly negotiations, as one would have if you have to come up with a contract from scratch. And that also makes them cheaper to use. And that's why what we see is that especially SMEs are relying very much on this instrument. And I think more generally, and that also relates a bit to what Denise was saying, what we think is that because they really create this standalone data protection regime, they set up their own sets of data protection principles, rights, and obligations. This is an instrument that can also bridge differences between data protection regimes in different countries. So they can also be used to transfer data to countries that may not have or may not yet have very developed data protection regimes. So as I said, in the EU, we've had them for about 20 years, but there was a clear need to modernize them. So a few years ago, we started that process. We very much relied on feedback from stakeholders to understand what worked well for them or what had to be improved. And the outcome was a modernized set of clauses that was adopted in 2021. And the main changes that we introduced were related to different aspects. I mean, one of them was to align them with the GDPR, because of course in the meantime the GDPR entered into force, and there are some developments compared to the previous data protection regime. So we had to adapt, for example, to some new accountability requirements, transparency requirements, and so on, and we had to reflect them also in the model clauses. We also wanted to incorporate the clarifications that were provided by the Court of Justice in the Schrems II judgment, which is all about the assessment that companies have to make of the legal framework in the country of the importer, and whether the importer will actually in practice be able to comply with the clauses. So we incorporated those clarifications in the SECs really as a way to guide companies through the different steps that they have to take to comply with that judgment. And the last, and maybe even I would say the most important reason why we modernized them was really to adapt them to the modern digital economy. I mean, very often we heard from stakeholders that the old clauses that we had were quite rigid. They were only meant for two contractual parties. They could not be, they didn't provide a lot of flexibility, whereas now you have often very long, very complicated processing chains that can also change over time. So we wanted to cater for that by providing one set of clauses, but with different modules that can be, depending on specific transfer scenarios, can be used, and also providing companies with flexibility to add new parties throughout the life cycle of the contract and so on. So as I said, the SECs, the modernized ones, were adopted in 2021. And then last year, we also issued a guidance document, a Q&A, where we answer some of the questions, comments that we have received from stakeholders based on their first experience with using the clauses. So I would say our work on the SECs, on our own SECs, is, let's say, done. But now, since, as you also mentioned, we see more and more countries and regions developing very similar tools, we're now very much interested in engaging with our international partners, like with ASEAN, to further facilitate the use of different sets of SECs to transfer data in different directions over the world.
Thank you so much for that very, very great overview. Philipp, do you use standard contractual clauses? And if you do, how are you dealing with the new complexity of having to assess third countries? And is that in any way a barrier for you to rely on standard contractual clauses when you're transferring personal data? Have you seen sort of a difference there? And perhaps you can also address what Alisa was just saying, that the new set of clauses seems to be also a bit more flexible because it introduced additional modules.
Perfect, yeah. So I guess I'm here to provide the user view, Gabriela and dear colleagues. So Allianz, you said it, we're a big financial services company and have a large personal data footprint. So we have 150 million clients, 150,000 employees in 64 countries. And we're almost in all, certainly in all EU, but also almost in all ASEAN countries. And, personal data is really going back and forth, the HR departments, exchanging staff, reporting line, development of employees, but also of customer data. And you may be insured with Allianz, if you travel somewhere, if you have medical accident insurance, right? That data must go cross-border. So we're really dependent. And then the other part of that is really, and we all know that many of our big service providers are now US companies, right? So somehow data has to go to the US or maybe accessed, right, by US parents. So it's almost for us impossible to say we're not transferring personal data. When we speak about Allianz, so the company's internal data, we have approved binding corporate rules, right? So that takes care of that. But then what's really missing is, to the transfer to the other cooperation partners, to the service providers. And there we're really grateful that we have the first and foremost EU standard contractual clauses, but also ASEAN ones are also very useful. And it's really, as the colleagues have said, it's so much easier when you negotiate with a provider. You don't have to explain much. Say these are the clauses, and they know them, and you fill out the annexes, and all good, and no approval needed, as you said, Alisa. So very, very business friendly. However, then we all know there's Schwemms too, right? Gabriela, it's what you alluding to. So it's not so easy just signing the contracts. Obviously, you have to stick to the contract, but there's even more asked, right? From a European Union perspective, we've been asked really to check whether the transfer of the data is necessary, right? Whether it can be limited, or whether the data can be encrypted and the encryption key held in Europe. And what we do is now transfer impact assessment. So as a company, before data should go somewhere and before we even sign the clauses, we are really doing a risk assessment and say, data, does it really have to go there? Can we limit it? And if so, what are the risks, of the receiving country? Then you have various tools from law firms which assesses the risks of the third countries, and then you come to a decision, and then we sign the data, and off we go. And this is now also interesting. You said maturing the SECs. That is also being checked by European data protection authorities. We regularly get questions, and I think rightly so, where the authorities are checking, are you signing these clauses? Are you doing the risk assessments? But in a nutshell, really great instrument. And I'm now also curious, on the further discussion, how we further evolve that mechanism, because I think what was also said in the intro, there are more and more, standard contractual clauses in parallel, and our data goes all sides, right? And then if we have to sign EU model clauses, ASEAN model clauses, Chinese one, the Ibero-American one, it's getting complex again. But maybe we find a solution there, right?
Thank you so much for that overview. And indeed, when we're seeing, I would say, more and more procedural barriers and more difficulty in having data flows, and we know how essential they are in today's day and age, an initiative that actually tries to eliminate some of those barriers is quite exciting. So for this second round, I want to go a bit into more detail on the initiative of the European Commission and ASEAN, and understand what is this guide that you are launching. Why do you think it was a good idea to engage in this effort? Let's start with that, actually, Denise, and then we'll go to Alisa.
So a couple of points. I think the first is the convergence between the EU SECs and the ASEAN MCCs. I think even though there's been a lot of discussion about the variation and the differences in different legislative frameworks, a lot of them do reference internationally recognized data protection principles, such as that established by OECD and APEC. We did a study, and we did find that there was a significant overlap between key principles and concepts, and I think there was, Alisa referenced that as well. And in addition, again, we also found that the use of contracts is a common data transfer mechanism for companies today. Within our Singapore context, we found that about 60% of Singapore-based companies do use contractual clauses or some sort of BCR or intra-group contract. So it's clearly an important mechanism. This guide was really a collaboration between the two parties, ASEAN as well as DigiJust, and it highlights, I think, quite clearly similarities and differences between both sets of clauses. And the aim is really to facilitate common understanding, to ease contractual negotiations between ASEAN and EU business partners. And it creates a baseline standard for that conversation to happen through mutually acceptable best practices with a view to building that sort of international consensus and convergence. What we hope is that it will help level the playing field, and we believe that it will especially benefit small and medium-sized businesses that may face resource constraints and find it difficult to navigate the sort of complex rules otherwise. I think if Allianz has trouble with it, what more smaller companies that may not have that sort of expertise or resources to navigate it. So we believe that it's a good first step, but also a testament to our collective commitment to sort of harmonize as best as we can, or rather just to find commonality between data transfer mechanisms in order to facilitate data flows. And I think this is really just a testament to a strong economic relationship that ASEAN has with EU, which continues to be very important to us.
Thank you for that. So we understand that this is a first step, and it's aimed to at least give the same vocabulary, right? And to be used by small and medium-sized companies as well as large companies. Alisa, let's go a bit to the thick of it. What is common in the two sets, and do you see a path forward for, let's say, an even more clear interoperability? And if you please, so I won't go for the microphone again, can you also address what are the biggest differences, and where do you see that more work and more dialogue is needed to bridge the two sets?
Thank you. Maybe first to start, because now we've been talking about this guide, can I ask the colleagues from the conference to put up, we have prepared a slide where, yes, so this is just to show you, because we just published the guide. It's now available on the Commission's website and on the website of ASEAN. So you have the links up there, and this is how it looks like to give you an idea. So we have basically put the ASEAN MCCs and the EU SCCs, the two modules, the controller-to-controller and controller-to-processor modules, next to each other. So you can see a page that, as an example of how the guide looks like. And essentially it compares the two sets of clauses, always identifying what are the commonalities, and then explaining what is specific or what additional requirements may exist under either set of clauses. So you can already see, for instance, on the page that's on the slide, I mean, there is really, as Denise already said, the basic concepts are very much the same in the two sets of clauses. So when we look at the key notions, so I don't know, definition of personal data, processing, the notion of controller and processor, they're essentially the same. The structure is also very similar, so both sets of clauses have this modular approach. I think the ASEAN MCCs have the two modules, controller to controller and controller to processor. The EU has two additional ones, but I would still say that these first two are the main scenarios that actually happen in practice. Another, I think, similarity is how the relationship between controllers and processors is regulated. So, for example, a requirement for the controller to provide instructions to the processor, some specific contractual requirements. Also, the key principles are very similar. So, purpose limitation, data accuracy, storage limitation, and so on. And the idea really with this guide, because this is only the first part, the idea is really to provide this overview to companies to make it easier for them to identify what they actually have to comply with when they use these two sets of clauses. You also asked me about the differences. I would say the main difference comes from the underlying legal framework, the fact that in the EU we have a harmonized legal framework. We have the GDPR that sets a clear standard for what should be in these standard contractual clauses. In ASEAN, as Denise explained, not all countries have the same data protection rules, and that is reflected in the clauses in the MCC. So some aspects, in some parts, they refer back to national law. But I think what we've tried to do with this guide is also explain what this means in practice for companies, what reference point they can take in national laws or in the ASEAN data protection framework to comply with the clauses. So we've tried to also address that aspect in the guide. So as I said, this is basically a first step. This is the beginning of our cooperation. What we now want to do is to operationalize this, to make this more practical. Now we have published this and we want to invite stakeholders, so including everyone here and of course Allianz, to provide input, to provide their feedback, their experience with using the two sets of clauses, what they are doing to comply with them. And the idea is to compile sort of a set of best practices of companies using the two sets of clauses, and then turn that into a second part of this guide. I don't know, Denise, you want to?
Thank you so much for that. I can't wait to look over it, but I'll have to wait a bit. Philipp, you've been already using the two sets of clauses, as you said. How are you seeing this initiative? Do you find it useful? And please feel free, if you don't find it useful, tell us. because the second part of the question is an opportunity for you to already give feedback to the initiative if you would find some specific points that you would want to see addressed perhaps in the next step or in this particular step. And how would you advise other industry representatives, CPOs, DPOs in the room to engage with the process?
Perfect. Yeah, thank you. I mean, and I encourage you taking a look at the guidance, and it's really amazing and even surprising how similar the SCCs are, right? And you make this, you can see there on the first page a really useful synopsis, right? And it's almost all very, very similar, as you say. I mean, from a business perspective, and maybe, this is coming over the next years, would be really good if we just had one set of clauses, right? Because the data tends to go both ways, so you need both contracts, right? I mean, I know that is a way, right? But maybe it's also an evolution, as you said. I mean, the European ones are 20 years old, right? And from a business perspective, we find quite useful these additional sets as well, right? The controller to the processor to processor and the processor to controller, because in practice we often needed that, then it wasn't there and we had to draft it ourselves. Then the question was, do you need now an authorization? What you do? But perhaps that could be also then added at some point to the ASEAN ones. And then the other thing is a little bit a question in principle. We as companies usually don't like regulations so much. But in this case, it may be different. It really helps us that the EU standard contractual clauses are mandatory, right? So we don't have a big discussion with service provider in the US. Do we really need it? And are you sure? And maybe that clause not, and that, and we can say no. It's a EU Commission decision. You need to adhere and full stop, right? While, as I understand, the ASEAN is more voluntary, although in Singapore or Indonesia, you have these data export rules, but maybe if the political process allows that, you could also come to a mandatory enforcement there, right, of the ones. And maybe then one particular which struck me from a European view is the third-party rights, right? And I think in the ASEAN, it's not a direct rights to the concerned individuals. So in Allianz, that would be, right, we're contracting under companies, Allianz, and let's say the outsourcer, but under the European SECs, our customers or employees have direct rights to enforce the rights. I think that's also different under ASEAN. That's also an interesting one, and maybe from a civil rights perspective, something which is desirable. But overall, really amazing project, and from an industry perspective, we're grateful for that.
Thank you so much, and thank you for your honesty and for the already great feedback. And I saw that Alisa was noting there while you're making suggestions. So just a small announcement. We will be taking questions. I know there are about 1.2 billion elephants in the room, so please be gentle. If you want to ask a question, there is a microphone there, and we will be taking questions. I'm not sure if there is another mobile one from the organizers to walk around. Now, my last question for the panel is, what are some of the next steps? Again, this is a wonderful initiative. I think all of us here in the room are very supportive of convergence, interoperability efforts like this one. What's next? Will there be, I already understood the second part. So perhaps let's go first to Denise from the ASEAN perspective in terms of next steps, and then to Alisa to perhaps also look outside of ASEAN and the EU, and what do you have in mind as future initiatives?
I think firstly, just echoing what Alisa said, I think the MCC, SCCs are just the first hurdle. As businesses know, contractual negotiations is really just the first part, because the next part is then to put the contractual obligations into practice. And even among ASEAN states, the ASEAN MCCs were not intended to be used in isolation, but really supported by sort of technical measures, process safeguards, other forms of governance controls, and that references back to the ASEAN data management framework. So for us, the next step will be, and also bearing in mind that not all ASEAN states, as mentioned, have data protection regulations, it's really about speaking widely to businesses to understand the different use cases, and then listing out some of the practical measures that companies can take to maybe sort of implement alongside so that they can meet the requisite standards. And then that allows for data transfers to happen. So we see it as a range of measures that can be taken, legal, contractual, but also other technical process measures to add on. And that's a very practical way forward for companies to be able to operate across borders. And we really looking at it from the perspective of the company or the organization, we hope to put them in good stead to be able to do the business and for data to cross borders, regardless of the size of the company or where they're from. So that is part 2 of our guide, really putting together the operational framework. And of course, beyond that, we hear the call for sure. A global set of contractual clauses would, of course, be ideal for companies with a global footprint. We understand the difficulties of having multiple sets of clauses, but the reality is, I think, in the immediate future, you will have differing levels of data protection. That is our current operating context. And it's very seldom an apple-to-apple comparison as well. So what we're trying to do now is really to have model contractual clauses as a whole gain traction, and I think it really has already. And then to build these multiple bridges, to bridge the different sets of contractual clauses, already that creates a lot of convergence and in a way harmonization, at least from the perspective of the company that has to operate them. We think this is a practical way forward to find common ground, and we on our end will be hoping to build on that.
Yes, I will perhaps move a bit away from the practical side, more to the political aspects. Maybe first to say something about the cooperation between the EU and ASEAN on this. Some of you may know, actually, in December of last year, there was a summit between the EU and ASEAN. And at that occasion, actually, there was also a statement that was adopted that actually recognized, the leaders recognized the importance of effective data protection rules. And they also indicated their work their intention to work together to identify these commonalities in our regulatory approaches and to further facilitate safe data flows. So I think that the work that we have done now is a very concrete contribution to this work. And it's really an area where I think we can bring some tangible benefits to companies that are active in both regions. And I think with this, the EU and ASEAN can perhaps lead the way also a bit in the rest of the world with this work, because as we've already mentioned several times, there are now more and more countries that are developing model clauses or that have model clauses. I'm thinking about the UK, Argentina, Switzerland, New Zealand. And we also see it at the regional level. So I think another regional organization that has developed clauses, you already mentioned it, is the Ibero-American network, which are also very close, I think, to the 2 sets of clauses that we're discussing here. There's also ongoing work in the Council of Europe to develop model clauses that we hope will also be finalized soon. So we see all these different clauses, and we think perhaps the cooperation that we're doing here can then at some point be extended also to these other regions to see whether we can really try to bridge all these different clauses. I don't know whether we at some point will get to a global set of clauses, but in the meantime, I think this is already important work that we can do.
Thank you so much for that. Philipp, any last points on the wish list for the future of such cooperation? Please.
I mean, Alisa and Denise already said it, right? I mean, one global set of rules would be great. I mean, you're probably aware it's not really comparable, but they're the CBPR, models for binding corporate rules globally. Maybe then this could be also a model for SECs, right? And maybe one thing, it's totally not related to ASEAN, but what businesses are now very busy also is with the Chinese SECs. And you may know that their deadlines are now for June 1st to really have them in place. And, that is now also keeping the businesses very busy. But if it gets too complex, if we have to sign too many sets, it's against international data flows, and obviously we want to help digitalization data flows. So the project to globalize these SECs and MCCs are very welcome.
Thank you so much for those remarks. Questions from the audience. Now is the time. Any takers? There is a question in the back. Is there a mobile microphone from our colleagues there? Or, I think the gentleman is going to use the fixed one. Okay.
Hello. Yeah, I'm a tech reporter, so I should know how to turn on a mic. But Matthew Newman from MLEX. So yes, one of the 1.2 billion elephants in the room with SECs. The Irish Data Protection Authority Commission has just ruled against SECs for Meta and levied a 1.2 billion euro fine. So I'm wondering from Alisa Vekeman if she can tell us a little bit more about the status of the replacement for these SECs that should be coming. I think before the summer is what Commissioner Reynders has said repeatedly, but maybe she can give us more of an update. And just as a corollary to that, if there is no agreement, what happens? Do the companies just rely on SECs and then sort of take, is it sort of, will the data protection authorities pursue those companies that continue to use them? They might even be pursuing them now until there's an agreement. So if you could address that issue as well. Thanks.
Yes, thank you. It's I guess a question to be expected. I mean, first of all, just to clarify, there will be no replacement of the SECs. The SECs are a valid transfer tool. This has not been called into question by the decision of the Irish Data Protection Authority. I think what is, of course, important to keep in mind that what happened in this case, the Irish authorities simply applied the Schrems II judgment to this specific case, and that's what it had to do. The case originated in Ireland, ended up before the Court of Justice, and then simply went back to the national level. So I think the Irish DPC looked at how Meta was using the SECs in this specific case to transfer data to the US in light of the findings of the Court of Justice on the surveillance regimes in the US, and in light of the conclusions of the Irish DPC that Meta had not put in place sufficient additional safeguards to address that. They concluded that these transfers were happening in violation of the GDPR. So I think we have to keep in mind that this is really simply an application of the Schrems II judgment in a specific case, so it does not affect the SECs as an instrument as such. So I guess what you were referring to is rather the work that we're doing with the US on the EU-US data privacy framework. And there, of course, all of the safeguards that we have negotiated with the US that are reflected in a new executive order that was issued by the US president last year. The purpose of these negotiations was precisely to address the issues that were identified by the Court of Justice and that have now also been referred to by the Irish DPA in this specific decision. So this new framework, or rather the safeguards that we have negotiated with the US, will address these issues. We are in the adoption procedure for the new adequacy decision on the EU-US data privacy framework. I mean, as I'm sure you know, we have received an opinion from the European Data Protection Board. There's been a resolution of the European Parliament. We are now working on a revised draft of the decision before we can then move to a next step, which will be getting the vote from our member states. And then if everything goes well, our plan is still to be ready by the summer. Of course, I'm sorry if I'm being a bit long on this, but I have to give the full story. Of course, this is what we're doing on our side. There's also still work to be done on US side. They actually have to implement these new safeguards. So intelligence agencies have to update their internal procedures, and the new redress mechanism has to be set up and made available to EU individuals. So that can also have an impact on the timing. It's only when all of these different elements are in place that we can actually proceed with the adoption of the final decision. But as I said, our plan or the timeline that we're working on is still to do it by the summer.
Maybe some additional comment, where we also said the SEC is not just about signing the agreements, it's really that transfer risk. And if a company now fully transmits all data to the US, can really ask ourselves, is that proportionate? Because there are many other US companies who are relying on EU data processing, right, where the EU servers are. And I think that is the other important component, together with the SECs, where you see, can you also reduce your international footprint and the risk exposure, right?
Thank you, Philipp. So you're not preparing the pigeons to fly the day.
No, but you have a EU data center, right?
True. We do have time for another question. Also the last question.
I'm Simon Ania, I'm the Global Data Protection Officer at Uber. First of all, congratulations with this effort. It shows great cooperation between ASEAN and Europe, and I would think that could taste for more. What I mean is, still SCCs in this new framework are great, but you still need to execute them. Now, if we make a parallel with Privacy Shield, where companies in the US can certify against a set of criteria which essentially mimic, well, you can debate GDPR or the previous data protection directive. You now have a combined set which potentially companies in ASEAN could certify against and then only do that once. And then you could arrive at some form of an adequate decision. Is that something under consideration, or am I being too creative here?
No, I think this is not something that we are discussing at the moment. I think the example of the US, where it's indeed to be able to adopt an adequacy decision, we're relying on a system of certification, is a very unique one. It's the only adequacy decision that works like that. And the reason is because there is no federal data protection law in the US at the moment. So we had to create something to compensate from that, for that. But normally, of course, an adequacy decision is based on an assessment of the legal framework in a specific country, of the data protection requirements, but also all of the rules that relate to government access to data. So I think that should still probably be the normal course of action for an adequacy decision. Certainly a creative idea. I've taken note of it. I don't know whether this is actually something that will happen, but yeah, I think for the moment, this is not something that we have ever discussed.
No, I think we appreciate the sentiment, which is the same sentiment that a single system or a system that companies can navigate easily will bring down business costs and compliance costs. I think that the reality is it is a step-by-step process, and we're building small bridges. Hopefully, in 5 years' time, when we have this conversation, it is a different landscape. But I think for today, it is very much celebrating at least some initial steps to create convergence.
Great. Do you want to weigh in on the creative idea, or?
Can support it fully.
Great. So we do have time for one more ardent question, if there is one. Let's go. Okay. Yeah.
Hi, I'm Maria Salusta from the European University Institute. Thank you for this great session. It's actually, I think it's a simple question. As the SECs are pre-approved, is there any consideration to collect the data on just that the companies submit the information saying, we are using this? And I don't know about ASEAN, but does that exist, that the companies would have to say that, okay, we're using the model contractual clauses to just have more information of how many companies are really using them, and to use that as kind of showing like, okay, this makes sense, let's see what we can do more here. Thank you.
So indeed, I think this is something that we are tracking and looking at. Of course, not at the individual company level, but at an aggregate level, we do speak very closely with companies and with business federations and associations, which is how we came up with the ballpark figure of 60% who really rely on some sort of corporate contractual clauses as the main lever and mechanism. So I think I agree very much with the sentiment that it is important to understand the reality on the ground of what companies, big and small, are doing, bearing in mind, of course, that at the end of the day, data is moving across borders more often than not these days.
Yes, I think the answer from my side would be very similar. At the moment, we are not tracking this specifically. I think it would indeed be interesting to have this data, to have these figures for now, because I also mentioned, 80 to 90%. We're basing ourselves on some figures or so information that has been collected. I think this case, it was a trade association there are some reports where they give these figures, but we ourselves are at the moment are not doing this.
Well, thank you so much for that. And it was truly a great conversation on the hottest topic of the day, in a sense. Congratulations for the effort. And thank you so much for joining us after lunch for this. Thank you.